evening to today's discussion. Just waiting for a couple of minutes for people to join in, and then we'll begin today's discussion. All right, I think we are good to go. So, good evening, everyone, once again, and a warm welcome to today's discussion on the impact of recent Supreme Court judgment on contract and tendering practices. In the past few years, India's Supreme Court has delivered several landmark rulings that have fundamentally altered how government contracts and tenders are awarded, executed, and challenged. These judgments have redefined key principle judicial review and fairness in tendering to the interpretation of bid conditions, arbitration clauses, and the doctrine of public interest. As India positions itself as a hub for infrastructure and public private partnerships, understanding these evolving judicial trends is more critical than ever, not just for lawyers, but for businesses, government officials, and policymakers alike. Joining us today is an esteemed member of the legal fraternity who has advised both private and public entities to complex contract disputes and procurement reforms. Today, we will look at how judicial procurement pronouncements are shaping the future of government contracting, and in India, what compliance, strategic, and ethical lessons we can draw from them. So, I would like to introduce today's guest for today's discussion, Advocate Medhavin Bhatt, who is a legal expert with over 16 years of experience and expertise in real estate, corporate law, and litigation, recognized among LMG's 40 under 40 rising stars. So, first of all, welcome to you, sir. Welcome to today's discussion. Thank you so much for joining us.
Thank you. Thank you so much for having me.
So, to begin with today's discussion, I would like to ask you about how the Supreme Court recently has, reshaped the legal landscape around government contracts and tenders.
See, not only recently, but over the past few years also, the Supreme Court has significantly redefined how public tenders are viewed. Not They are viewed not just as commercial transactions, but also as exercises of public power. So technically, the court has reiterated that the state has contractual freedom. Its discretion must operate within the bounds of fairness, transparency, and equality under the Article 14 of the Constitution of India. So, to summarize, tendering is no longer just an administrative process, which it used to be, but now a constitutionally governed one where arbitrariness, opacity, or bias can invite judicial scrutiny.
Right. And do you think that these judgments reflect a shift towards more transparency and accountability when it comes to tenders?
Yes, absolutely. In fact, the court has made transparency a legal mandate.
Right.
Today, government agencies must not only act fairly, but also they have to act in a way that they are maintaining records, applying evaluation criteria uniformly, and giving reasoned decisions. So the ad hoc manner in which the tenders were allotted, that process is no longer there. This has made not only the procurement more structured and documentation heavy, but also ensures that both bidders and authorities operate in an accountable and reviewable framework.
Correct. And do you think that the courts have become more interventionist, or they're restrained in when it comes to reviewing tender conditions, contract awards?
No, I would say that the courts have struck a very fine balance. They are not interventionists merely because a bidder is unhappy with the result, but where arbitrariness, discrimination, or lack of fairness is evident, the court has not hesitated to step in. So
Right.
the principle of judiciary is very clear that judicial review examines the process, not the merits. So long as the process is fair, courts will replace the authority's commercial wisdom.
Right. And according to you, to what extent should courts be interfering in contractual matters involving the state or public bodies?
See, according to me, I feel that the judicial interference should remain supervisory and not substitutional. Courts rightly intervene when the procedure are tainted by malafides or discrimination, but they should avoid re-evaluating the technical or commercial decisions.
Right.
The role of judiciary, I feel, is to ensure legality and fairness and not to sit as an appellate tender committee.
Correct. And do you think in the recent judgments they strike a balance between protecting fairness and also respecting commercial discretion?
Yes, they do, because the court has consistently recognized that the government must have commercial flexibility, especially in complex projects.
Yeah,
India being a developing nation, doing too many infrastructure projects, there has to be some flexibility. However, the courts have drawn a very firm line. Discretion cannot become a cloak for arbitrariness. And I feel that this balance ensures procurement remains both commercially practical and constitutionally compliant.
correct. And do you think, I mean, you mentioned arbitrariness twice now. Do you think that the interpretation of arbitrariness or public interest has evolved by the way of these rulings?
See, law per se is an evolving subject. So,
Yeah.
yes, definitely it has evolved.
Okay. And how have these judicial pronouncements affected how government agencies now draft or evaluate tenders?
See, in my view, there has been a cultural shift.
Hmm.
The government departments are now drafting tenders with far great precision, ensuring that every eligibility condition is clear, proportionate, and justified. Evaluation committees also maintain detailed records of why bids were accepted or rejected. And this has not only brought discipline, predictability, but also defensibility to procurement decisions.
Correct. And now, what is something that bidders should keep in mind before, or what practices should they be doing in order to avoid disqualification?
See, first of all, the tender document mentions everything. Okay.
Right.
So, for bidders, precision is everything. Each requirement must be exactly met as stated. No assumptions, no omission. They should submit necessary documents and complete the documentation, seek clarification when terms are ambiguous, and preserve all records of communication. And I feel, in my experience also, ultimately, a well documented bid file is a bidder's strongest safeguard if a dispute arises.
Correct. And do you think that these judgments have increased litigation risks or have they helped in streamlining dispute resolution?
In the short run, yes, litigation has certainly increased.
Yeah.
Bidders have now more become aware and proactive.
Yeah.
But you see, in the long run, the clarity of judicial standards will reduce disputes. There will be a precedent, there will be clarity on law, there will be a clarity on process. And once these authorities internalize these principles, both sides will benefit from this predictable, transparent process, making litigation more the exception than the rule.
Correct. And then, do you think that now, through these judgments, we will see, arbitration clauses being influenced, or settlements also being evolved because of the recent Supreme Court judgments?
Yes, I feel the Supreme Court has reinforced that the arbitration remains the preferred route for commercial disputes, but it cannot be used to shield arbitrary administrative action. So, when fairness or constitutional principles are violated, courts retain the right to intervene under the writ jurisdiction. This dual approach promotes arbitration but not at the expense of accountability.
Right. And do you think we're seeing a trend towards enforcing standard from form contracts more strictly against private players?
Yes, very much so. The court has made it clear that if you participate knowing the tender terms, you are bound by them. And challenges to these the standard forms are rarely entertained unless the terms are patently unfair or illegal. And this makes it imperative for the bidders to scrutinize every clause carefully before submitting their bids. Due diligence is now honestly non negotiable.
Right. And what further legal reforms or clarifications do you think are needed to make India's tendering framework more predictable and business friendly?
See, India, I feel, needs a consolidated public procurement law that standardizes the tendering principles across all levels of government.
Right.
Codifying definition of arbitrariness, timelines for grievances redressal, and a clear cancellation procedures will reduce ambiguity. And according to me, such a framework would promote uniformity, limit litigation, and enhance investor confidence, especially for infrastructure and PPP projects.
Correct. And then a question that I think everyone asks these days is, then how does technology play into this? Do you think incorporating technology in this, like e-tendering, do you think it will align and bring more transparency and fairness in the system?
See, AI is the future.
Yeah,
And honestly, technology can be a tremendous enabler, but only if implemented transparently.
yeah,
E-tendering platforms must create auditable timestamp records that can withstand the judicial review. As AI tools tender procurement, the focus will shift to explainability. Every algorithm decision should be traceable and reviewable, and courts will expect not perfection but accountability in design and execution.
right. And like, how, as legal practitioners, right, how are lawyers able to help clients navigate this evolving environment?
See, lawyers are now not only advisors,
Yeah,
but we are also now strategic partners in procurement.
right,
So for government clients, we can help design fair, defensible tender processes. For private clients, we can conduct pre-bid legal reviews and build compliance frameworks. Most importantly, I think we can guide the clients on when to litigate and when to negotiating, ensuring that legal remedies are used to protect rights, not stall public projects.
correct. So I think we have more or less covered all of the main questions around tendering, government contracts, that kind of thing. What would you kind of, like to say in the end? Maybe it could be an advice, or just in general comment on how this industry is evolving.
See, it is eventually an evolving industry. What happens is that you need these kind of projects because if you want the nation to develop, tenderings and contracts are the key to it. You
Correct.
have recently seen too many infrastructure projects also. I only wish, hope, and pray that whatever tenders are floated and whatever bids are made, there should be some transparency, there has to be clarity, and there has to be some accountability in the entire process because nothing can happen at the cost of taxpayers and common people.
Correct, correct. So, just to clarify again, transparency is not just important for the parties involved, but also the citizens of the country.
Yes, because eventually I feel the citizens are the ones who are affected by a lot of these infrastructure projects.
Right, right. And these infrastructure projects that we're talking about are not small scale projects. I mean,
Yes,
they're
yes.
at a very large scale, a lot of money involved, which is more or less our money that us as
Taxpayers' money.
taxpayers are paying. So I
Correct.
think it's doesn't, like, a lot of times I feel like we as citizens think, how does this concern me? I'm not sure because I'm not a party involved in it. But I think when you look at it deeper, you understand that, okay, I'm paying taxes to the government and my tax money is being used for this. So you as a citizen also need to be aware of what is happening with the money that has been that you're paying as tax. And I think transparency in this is extremely important from that aspect as well.
Yes, it certainly is.
Right. So, I mean, again, I think today's session we clearly highlighted that Supreme Court's judgment is not just shaping interpretation of contracts, but it's influencing how tenders are drafted, evaluated, and enforced across India.
Yes,
We've also seen how balancing judicial restraint with accountability, emphasizing transparency, fairness, and public interest, while we also are reaffirming commercial discretion and contractual sanctity. So while we are looking at making a more transparent process, we also need to make sure that the commercial discretion is maintained, and we're also keeping their interest in mind, because there are private entities also and players also involved in this, and we as a nation want to develop, and I think that is one way we can do that. And I think as we move forward, collaboration between law, policy, and practice will define how we build a more transparent, efficient, and equitable procurement ecosystem. So yeah, I think today's was a very short live session, but we have been able to cover more or less most of the important questions that we had today for you. I would like to thank you, Advocate Medavin, for coming in and taking on today's session alone. We were supposed to have more panelists with us who unfortunately couldn't join us, but Advocate Medavin so graciously attended and took upon the discussion himself, and it was, I think, a wonderful discussion.
Thank you. Thank you so much for having me. And it was a pleasure having this discussion.
Thank you so much, sir. And we will see you soon in the next discussion. Good evening to everyone.